other secrets about estate planning documents. And again, I'm going to keep my focus a little bit on long-term care costs, but not necessarily just long-term care costs. A will is a very important estate planning document, especially in the state of Washington, if you are worried about long-term care costs. Why is that? Because in the state of Washington, when the first spouse dies, if their will contains a special kind of trust for the surviving spouse, we call it an asset protection supplemental needs trust. If the spouse who is dying and dies has a will with that special trust in it, then their assets will all go to the trust for their surviving spouse. A probate will be required for that to occur, but that is the way that we can take the deceased spouse's assets and put them in a trust for the surviving spouse. Now, why are we putting it in a trust for the surviving spouse? Well, imagine Joan. If John were to die before Joan, and John has all the couple's assets, but Joan's on Medicaid, but John dies first because he has a heart condition, and Joan is still doing okay in the memory care facility with her Alzheimer's. He dies first. All the assets that are in his name will fund the trust for Joan, and any assets in that trust aren't owned by Joan. And what that means is Medicaid doesn't count them as hers, and her benefits will continue uninterrupted, will not go to her care costs. And then when she dies, those assets will be distributed out to their children or to whomever they wanted to receive them. Again, the state gets nothing. This result of protecting assets for the surviving spouse against long-term care costs and to maintain Medicaid eligibility for long-term care can only be achieved through a will, at least in the state of Washington. That's our rules.